Welcome to Road to Recovery.
Hey there, welcome to Road to Recovery, advocacy and insights for trucking accidents with Sagi Shaked. Sagi is founder of Shaked Law Personal Injury Lawyers and is ranked as one of the top 100 trial lawyers in the United States by the American Trial Lawyers Association. With a wealth of experience in personal injury, wrongful death, and complex litigation cases, he passionately advocates for victims and has recovered multi-million-dollar settlements in damages for his clients. My name is Kevin Rosenquist, and today we're diving into a critical issue most people don't even know about: spoliation. What happens when a trucking company hides or destroys key evidence after a crash? Sagi, welcome.
Yeah, thanks for having me. This is one of my favorite talks.
Yeah, we've kind of touched on it before, but I don't know that we've ever really done a deep dive on it. So, what is spoliation in this context, and how does it come up in trucking accident cases?
Yes, so spoliation is the intentional or negligent destruction or alteration or withholding of evidence that's needed for a case. So in trucking accidents, you'll see it sometimes when the black box data is deleted. I mean, you can all understand why that's important. They mysteriously lose the driving logs that they're required to keep under the law. They don't preserve the dash cam, the interior and exterior dash cam. And then lately we've been seeing that they're scrubbing the GPS history of where the truck has been. So you start seeing stuff like that, and you start thinking to yourself, why would defendants and their insurance companies destroy crucial evidence, right? Obviously, we all know why. It's not to their benefit.
It's not a good look, that's for sure.
Yeah, not a good look. But then there's ramifications for that.
What are the laws that, as far as what's required to preserve, records after a crash? Is there like certain records timeline? Like what does the law say?
So you remember, we speak about trucking companies, we speak about the Federal Motor Carrier Safety Regulations. So those are laws passed by Congress. And what they do is they tell you the limitations for the different things that you need. So when we send out that preservation letter that goes out, we want them to immediately be on notice that they need to preserve certain evidence. Because if you don't send that letter out, trucking companies know that they don't have to keep all these items for a long period of time. So for example, you have the driver logs we talked about. Driver logs, they only have to keep for 6 months. And if you didn't send them that preservation letter, and they can make an argument, although I think it would be without merit, we didn't know that we needed to keep these logs. Of course they knew, but that's an argument they're going to make. So driver logs would be one. The vehicle maintenance records, usually they keep them for about 12 months. You want to make sure that those are preserved, because if there's something wrong with the vehicle, that would be something that you would want to know, that they didn't take care of what they were supposed to. The black box data, or the electronic data recorder, you want those right away. Now, I think it's going to be hard for a defendant, whether it's a trucking company or an individual, to say, I didn't know I was in an accident, unless it's a fender bender, which is not what we're talking about. I'm not talking about a scratch on a car. I'm talking about some real damage to a car. For them to say you didn't know there was going to be litigation, or you didn't know there was going to be a claim, it's kind of frivolous.
Yeah.
So you have that. And then, the accident register, or, the fact that they have to keep that for a certain period of time. Those are things that are critical to a case. The fact that they have to test their individual driver after every accident, alcohol and narcotic or drug test. If you don't ask for that information, it disappears. So you need to send that preservation letter out, make sure they preserve it. And that's when, if they don't, you start talking about spoliation and what could be the consequence for them.
Yeah, what are those legal consequences that a company can face if they're actually caught destroying evidence?
Yeah, so a lot of times we get these cases, and it seems like it's happening more and more and more, where evidence is being destroyed. Like, they'll only give you a certain part of the video. They don't want to give you a minute before. They'll just give you the second before. We don't get the minute before where the person's dozing off. So what are the consequences? Number one, You can have their entire defenses stricken where they don't get any defenses because without that video, for example, I could maybe prove my case. And it's unfair to me that you're deciding what evidence to destroy, you, the defendant. So the judge can strike their defenses, or the judge can give what they call a negative inference instruction to the jury. And that inference instruction would be something like that. You are to assume that that evidence was helpful to the injured person and
Oh,
that
wow.
they
Okay.
destroyed the evidence. So that could be something. So there's a presumption also that you can get that they are at fault because they destroyed the evidence. And then the most harsh of all sanctions is, hey, you don't get any defenses. What you did is completely wrong. You don't get any defenses. So that's always the best instruction if you're the plaintiff's attorney or someone representing the injured party or the victim, a family victim. You'd want to get their defenses stricken if you can. And that happens a lot when they play, funny games with the evidence, or destroy evidence or alter evidence, which does happen in cases. It literally does. We deal with it on a weekly basis. We have this happen in our cases. I don't. It's still going on. 25 years later, I'm still dealing with it. I dealt with it when I was a defense lawyer, where our clients were doing it, and we're dealing with it now. Even, in today's time, people think they can be slick and erase data from a GPS, and that we're not going to find out about it. There's forensic experts for all that stuff.
Yeah, that's sort of the thing. It seems sort of naive, doesn't it, to think that you could do that and not get in any sort of trouble. Like, I don't know. It's just so brazen, I guess.
It is. It really is. And they try to get away with it. And that's where you come into an attorney who, unearths every rock and just keeps going and going and going and, dot every I, cross every T until you get down to that information. And then lo and behold, they want to settle these cases because that's going to piss people off that, you took away their ability to present their case and now you want an unfair advantage at trial.
Are there other signs that you kind of look for that someone might be, that someone might be trying to get rid of evidence other than the obvious of them saying, "I lost it. I don't know what happened to it." Are there other things that kind of get your spidey senses up a little bit, for lack of a better term?
Yeah, if the evidence just doesn't add up. So we've
Ah,
had cases. Now they have electronic, where they record your hours electronically, the driver logs. But before that, I guess I'm pretty old now, right? Before that, it wasn't electronic, right? They'd have to have these hand logs, and the truck drivers, they would have three different sets of logs. One set of logs that they would keep themselves to determine how many really hours did they work. One set of logs to submit to the company, which were different than the driving logs that they had. And then one set of logs for the authorities, because if the authorities ever stop them, whether they're at the way station or wherever, they'd submit these false logs. And so we had a driver actually admit that he had three sets of logs. And now they're playing with the evidence. They're lying to us about what the evidence is. We have one time they submitted one set of logs, another time they didn't know what they were submitting to us. They submitted another set of logs for the same day. And then a third time it was a third set of logs, all for the same day. I mean, you really can't have three sets of driver's logs. On Monday, you were either doing one thing or another. You can't be doing 36 hours in a 24-hour period. It's just impossible. But so you have this alteration where they write over stuff or they change stuff. And, there's something called an audit trail where you can go back into any type of electronic data. Let's say it's a medical record, for example. You can go back and see if someone went into that medical record and changed something. So there's a trail, and that trail applies to the telematics. It applies to the GPS. It also applies to your black box data. So if people are playing games with that stuff, we're going to know about it. So hopefully they don't play games, but I can tell you it still goes on. We're dealing with a case right now with a video where the defense thought it was okay to cut the video off and not let us know what happened that whole minute before, where we asked for the 5 minutes before. And that minute before would have been a telltale sign of what really was going on with that driver. But of course, they didn't give it to us. So they're going to be facing a motion for spoliation of evidence or destruction of evidence is what they did in that case.
yeah, most every digital thing, whether it's your phone or a piece of software or something, there's always audit trails there. I mean, I feel like we all know that, right?
You would think, sometimes people think they're smarter than everybody else.
Yeah.
And they're not. I don't pretend to be smarter than anyone else. I know there's always someone out there who's, an expert at a specific field that knows more than me.
Sure.
And I'm going to use her to tell me exactly what, I can get from this information. I'm not just going to rely on, my knowledge. I know some things. I don't know everything, that's for sure. And I surely wouldn't play with, changing something around to my client's benefit. It is what it is. We deal with what we get, and we try our best from there, but we don't play games with the evidence. And I don't like it when they do it, and we expose them when they do it.
Is there any sort of difference between doing it, like, are they more, do they get punished more if it's after they receive the preservation letter, or does it not really matter?
Yeah, that's a great question. So generally, before the preservation letter, they can always make arguments, and they do. We didn't know, Judge. We didn't know this was going to turn into a claim. We didn't know we had to preserve this information. We preserved what we thought was proper. And so they're not going to be punished as much, even though that's like the standard, the standard answer they always give. It's like that's what they teach at defense schools, but once you get that preservation letter, now you're on notice. You destroyed evidence. It's different. You were put on notice. And usually when you're sending out this preservation letter, you want to send it by certified mail or by FedEx or by UPS or some sort of other proof where you can prove that they received that letter. So we had a case where they were trying to say they didn't receive that letter. And then I took the deposition of the person who does all the recording of every piece of mail that comes in. And we had their signature on that green card. And, I proved you were the person that received this green card. Yes, that's your signature. Yes, that's my signature. And you would agree that you received this letter. Yes. And then they eventually had to agree to it, and they destroyed a video in that case. And sure enough, the case settled. And it should have settled because, they were at fault, but they were trying to destroy our ability or hamper our ability to do it. So if you put them on notice and they destroy evidence, it's going to be a lot worse for them in terms of the sanctions, meaning the punishment that they're going to get from not being able to provide a defense, to having that presumption that, hey, you're at fault. You had evidence, you destroyed the evidence, and the jury, you're to assume that evidence was favorable to the plaintiff, the person that was injured.
You keep saying that you see it every week, that you see it all the time. And, like, how do you approach that when this is happening? Is there a special, thing that you have to do, that you have an accusation, if you will, or what is your process there?
So, I mean, when we get one of these, we know that they destroyed evidence. We get excited in the office. All the attorneys in the office, we're excited because now the defense, they're really screwed. They had a chance to legitimately defend this case, and they're trying to cheat, basically, right? And you get your hand caught in that cookie jar, you're going to have to pay. So we find out that someone destroyed evidence. We're now on the hunt. What could that evidence have shown? And then we want to start taking the depositions to prove that. Then afterwards, we have the transcripts from their sworn testimony. We'll file a motion for spoliation of evidence. And obviously, we're always going to request the most egregious relief possible, because if they take away our ability or hamper our ability to prove the case, we want that most egregious relief to be sanctioned against the defendant. So sanction them for what they did wrong. And it's sort of like a deterrence, right? You have punitive damages to deter, but this spoliation ruling that the judge will give, it's to deter other people from doing that.
Sure.
But even though there's a deterrence out there, and just like there's deterrence when we talk about, there's punishments if you commit a crime, people are still committing crimes all day long. Same thing here. People are still destroying evidence, thinking they're slick and they can get away with it. So there's that deterrence aspect. Does it work fully? I mean, you hope it works, but it doesn't always work because people still do it. And again, we see it all the time. It's ridiculous the amount of cases we have where the defendants are spoiling evidence, destroying evidence.
Yeah, I mean, you think I mean, they're doing it. Obviously, their counsel shouldn't and probably wouldn't, right? Recommend that they destroy evidence. You know what I mean? So they're just taking it upon themselves to do this, right?
Yeah, in all fairness to defense attorneys, I'm not saying they're bad people. They're not. And it's usually, I'd say 99% of the time, not the defense lawyers.
Yeah.
They're not the ones destroying evidence. They're not calling their clients, hey, we need to destroy this evidence. I don't think they're doing that.
Burn the video, burn the video.
Yeah. I don't think they're doing that. I think, could you have 1% of lawyers doing that are just bad apples, like you have bad apples in the medical field and bad apples in every field? Possibly. I would say yes. But generally, it's either the defendants, they knew about it and thought that they can get away with it, or they just, plain old ignorance. They just don't care. And some of them just don't care. And I don't have to preserve this. Who are they to tell me what to do? And you got to recognize if you're getting a letter from a lawyer's office, something's coming down the pipeline. You need to either get a lawyer, because the lawyer would tell you, do not destroy that evidence. Just like we tell our clients, don't destroy evidence, because we know the defense is going to want it. So we're not going to do it. We tell them not to do it. I don't want to have a spoliation case against my client, where my client now can't prove their case, or can't prove, the defense can't prove their case. We're going to help them just like we would want them to help us. Obviously, even if it doesn't benefit them, they should still do the right thing and preserve the evidence. But we don't live in a just world, so we're here to get justice for our clients. That's what we try to do.
That's why we call people like you, Sagi.
Exactly.
When trucking companies destroy evidence, they're not just breaking the rules, they're threatening your right to justice. If you've been hurt in a crash and you're worried about what's being hidden, visit shockheadlaw.com. Sagi will help you take action. This has been Road to Recovery. Be sure to like us out there, leave a review, subscribe. We really appreciate it. Sagi, great topic today. Really enjoyed the conversation.
Thank you, Kevin. Yeah, it was fun today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.